Van Wyk from Stellenbosch so far. If we can start, Chair. Thanks.
No, thanks very much, Mr. Matonsi, and welcome honorable members to this important public oral submissions, and also welcome all stakeholders in attendance and the Department of Home Affairs for attending this continued engagement with the stakeholders and members of the public in relation to the marriage bill that has been initiated as a result of the Constitutional Court and the Department of Home Affairs engaged in the white paper, and ultimately the bill that is before us. We must indicate that we've also traversed almost 8 provinces to conduct public hearings, and we've received sufficient support in terms of the affirmation of the bill, and also those that are not agreeing with certain clauses that are entailed in the bill. This gives us an opportunity to further consolidate our clarity in relation to the views that members of the public or stakeholders, political parties may contribute to strengthen the work that has been already being started. I must indicate that Parliament and the Portfolio Committee, we have not deliberated on this bill. We have not taken a decision as Parliament. We're carrying public consultation so that at the point that we're going to interface with the Department of Home Affairs and deliberations, and ultimately to the House, sufficient views has also been sourced from all corners throughout the country. We're fully aware that we've adjourned the public hearings, the last public hearing that we must conduct in Limpopo province. And once we've concluded that, we'll then deal with the report of all the submissions that has been made, and therefore the committee will have an opportunity to do that. So we welcome you to this important meeting, and we're fully aware that there's sufficient circulation of the bill that has been carried that seeks to rationalize all existing laws into one single statute. And as I've indicated earlier, that the Constitutional Court dealt with some of the provisions that are inconsistent with the Constitution from the Marriage Act. So this opportunity has been created, and I want us to note that we're going to allocate each of the stakeholders 10 minutes to contribute. As you know, all our public hearings, we conduct workshops. When the committee interface with the members of the public, we allocate 5 minutes. This assists us to manage time. As you know, that also members of the committee must join plenary at 2 o'clock. All the submissions that are going to be made will also request that be submitted to the committee, so that at the time we're going to interact, at least with point reference. But this also gives an opportunity to talk to members of the committee and also the public on the issues that you will be raising. We'll also invite the department through Advocate Malekate to respond on some of the issues that will be presented to the meeting, clarify, because the bill has been initiated from that front. And as I've highlighted, that the committee and Parliament, we have not yet interacted nor taken a decision on what must inform our course of actions once concluding this process. At the end, we'll then request Honorable Sihle Ngubane to facilitate closing remarks and a way forward on how we're going to engage. This is a 2-day public oral submissions, will convene tomorrow with other stakeholders. We must note, Mr. Matonsi, that now that other stakeholders are not in attendance, given the program, how we've scheduled it, it must not interfere a disadvantage others that have been joining to interact with the portfolio committee. In other words, if there will be those that are not yet today but will be there tomorrow, it will mean therefore we'll start with those that have been scheduled for tomorrow, and if times allows, we'll then interact with those that were not here, or otherwise they will have to submit their written submissions to the committee. Let me invite you, Mr. Matun, to do two things. One, if there's any apology that is going to be carried, indicate. Two, and also introduce all those that are in attendance so that we're able to manage the conversation proper without suppressing members of the stakeholders who will assist the committee on this proposed bill. Mr. Matonsi?
Yes, Chairperson, from my side, there's an apology from the Deputy Minister, as well as an apology from Ms. Ngobeni. From the stakeholder that I can see on the system here, there's Bianca van Rooyen from the Triangle Project, and also Etienne Smith.
Okay. Let me make it so easier for you. Let's start with the first. Let's start with Home Affairs. Who is in attendance?
From Home Affairs is Advocate Malakate and Mozi that I can see now.
Okay. On the agenda, let's start with the first stakeholders. Just invite them. If we check Oral Triangle Project, are you in attendance?
Yes, Chair.
Thank you. Freedom Religion South Africa. They're not in attendance. Stellenbosch University.
Yes.
Thank you. Free Society Institute. They're not in attendance. United Alma Council of South Africa. They're not in attendance. Al Jama Political Party.
Thank you. I'm here.
Okay. Thank you. Christian View Network. Okay, I think they're not in attendance. Yeah, we can proceed. We'll check the times, and I think because they've allocated, they might have noted that they are joining the meeting at this particular time. Let's now invite Advocate Malekate in attendance. Let me just verify that point.
Good morning, Chair, and good morning to the honorable members in attendance, as well as the those who are to provide the oral representations. Chair, I'm in attendance.
Okay. Thanks very much. We'll now invite all apologies have been carried, noted. We'll now invite, and I will request that at least we stick to time. If you go outside allocated time of 10 minutes, we'll also advise, but will not disrupt the presentation. We'll have a way to make sure that all of us will sufficient contribute to this meeting. I will now invite Triangle Project. Thank you.
Thank you, Chair. Am I audible?
Yes, you're audible, ma'am. Thank you.
Okay, thank you. My name is Bianca van Rooyen. I am representing Triangle Project on our joint submission with the Women's Legal Center. We thank you for the opportunity to contribute. Triangle Project is a non-profit human rights organization offering professional services to ensure the full realization of constitutional and human rights for lesbian, gay, bisexual, transgender, queer, and intersex plus persons, their partners, and families. Our organization is one of the oldest organizations of its kind in South Africa, dating back to 1981, offering a wide range of services to diverse and growing communities, including court support to survivors and of hate crimes. We also share this contribution with the Women's Legal Center, an African feminist legal center that advances women's rights and equality through strategic litigation, advocacy, education, and training. The center has a vision of women in South Africa who enjoy equal and substantive rights to their access to their rights. For our presentation this morning, we will focus on two parts. One, general comments on human rights, legislative and policy developments, which we believe is pertinent to the development of a marriage policy. And the second part, which are our comments and recommendations on the marriage bill. And so before we go into our recommendations, we believe it is important to raise several key issues as general comments for the process of policy and law reform that lies ahead. We submit that this broader understanding is critical for development of laws and policies that seek to address the legacy of oppression, injustice, and discrimination from our past. We therefore submit that in order for the Portfolio Committee to meet its constitutional obligation in respect of law reform, it must consider the impact of the legislation on all four key categories of sexual orientation, gender identity, gender expression, and sex characteristics, and the applicable human rights standards. It's also important that those drafting the legislation ensure that they have an accurate understanding and articulation of how these categories apply to the different groups within the LGBTQI+ acronym. In particular, avoiding conflating issues of sexual orientation with issues of gender identity and sex characteristics. We also remind the Portfolio Committee that LGBTQI people represent diverse groups in terms of race, culture, religion, language, geography, health status, socioeconomic circumstances, and disability and other positionalities. It is therefore important to have an awareness of great diversity and different positionalities within the LGBTQI+ communities when we develop laws and policies such as the bill. The Portfolio Committee needs to be alive to the lived realities of those most persecuted and excluded for being different within particular family and community. We also remind the committee of its regional and international legal obligations, noting that South Africa has legal and international legal obligations towards LGBTQI+ people in the recognition and protection of individual sexual orientation, gender identity, gender expression, and sex characteristics within different contexts, including marriage. The Yogic Carter principles are important to consult as it outlines state obligations on the application of human rights in relation to sexual orientation, gender identity, gender expression, and sex characteristics. South Africa's former constitutional judge, Edwin Cameron, was one of the international experts who developed the initial set of the principle. And the Yogic Carter principle covers a broad range of rights as they apply to LGBTQI+ people, including the right to legal gender recognition and the right to a family, which, among others, addresses marriages and other partners. As the marriage bill is important for the protection and realization of the human rights of LGBTQI+ people, the Portfolio Committee is encouraged to eliminate these misconceptions, inaccurate assumptions, and offensive language. We therefore urge the Portfolio Committee to become familiar with the SOGI's human rights language frameworks as articulated in the submission, including the resources that the references made by our organizations and other LGBTQI plus transgender and intersex organizations. We now move into our recommendations following the general comments. Starting with the LGBTQI inclusion in all customary and religious marriages. We submit that inclusivity can be created by bringing all marriages into one umbrella and recognize that people who enter or seek to enter marriages and similar relationships have diverse identities, backgrounds, and social, religious, cultural belonging that include and extend beyond their gender, sex, and sexual orientations. We remind the Portfolio Committee that LGBTQI plus persons have culture, custom, religious belief, traditions, and they have a desire to express them. We therefore welcome the inclusion of the language in Section 5, in Part 2 of the bill, which recognizes that a valid marriage can be entered into many different ways as long as it is celebrated in accordance with the respective custom, tradition, or religion of the parties entering the marriage. It is in Section 11 where this bill becomes contradictory, but we will get into that when we get to the Section 11 part. Polygamous marriage. We refer to page 20 and 21 in our written submission. We submit that if inclusion is a key outcome of this process, then Section 9 of the Constitution is to be given effect to. Therefore, it is an obligation to have more than just formal equality in the language and provisions that are made in the draft bills. The obligation extends to ensuring that lived realities of people are not only considered, but that we address the discrimination and prejudice present in the everyday lives. This will ensure that we achieve substantive equality in terms of Section 9. Polygamy should be recognized as an issue of equality as a value of our Constitution and rights in terms of Section 9. And therefore, if polygamy is recognized, that then not only should polyandry, which one woman or two or more men, be recognized, but also polygamy or multiple marriage relationships in all its forms, which would include instances where the persons in the relationship may identify as non-binary, woman, man, or another gender. We also note the need for SOGI's and inclusive language throughout the bill. It is encouraging to see that gender-inclusive language was introduced in many places. However, in the bill, there are repeated references to he or she, his or her, husband or wife or wives. And we therefore recommend using gender-neutral pronouns such as they and them, and gender-neutral terms such as spouse and spouses throughout, and referring to polygamy in a gender-neutral manner as multiple marriage relationships, so that all forms of marriage will be included regardless of the SOGI's of the persons involved. And now we refer to solemnizing marriages in Section 11. This section allows officers to refuse solemnizing marriages based on personal belief. And we believe that this is fundamentally unconstitutional. Marriage officers are state functionaries performing a state function, and the state does not have discretion to unfairly discriminate on the grounds of subjective conscious belief or religion. And moreover, we note that Section 11.4 was not present in the previous draft of the marriage bill circulated by the Department of Home Affairs. And we see no legal and justifiable reason for its inclusion in the current marriage bill. Our law has firmly entrenched the principle that individuals deserve dignity and equal treatment by the state, irrespective of their sexual orientation. Consequently, the state has both international and constitutional obligations to ensure that LGBTQI plus marriages are treated by the state using the same standards for heterosexual, cisgender, intersex marriages. The effect of allowing any marriage officer, even if they are not ex-official marriage officers or public servants, to have discretion regarding which person they are willing to marry, discriminates against LGBTQI plus people. The state does not have discretion to unfairly discriminate because of their own belief system against any individual requiring state services. And so the contributing organizations have actively been involved in advocating for engaging on the decision of Section 6 of the Civil Union Act, which allowed the state through its employees to object to performing marriages that are considered to be same-sex marriages under the Act. We have noted in the public discourse since the release of the discussion paper and the Department of Home Affairs Green Paper, and now also the marriage bill, that there are a number of lobby groups attempting to reintroduce this discriminatory provision through the law reform process underway. Am I still good with time, Chair?
Proceed,
Thank
ma'am.
you.
Thank
Thank
you.
you. We further recommend and also comment on the validity requirements and minimum age requirements on page 23 of our written submission. We support the requirement for free and full informed consent and recommend that this be defined clearly in the bill, in the definition section of the marriage bill. The consent aspect is especially important for marriages that are concluded in terms of custom, tradition, or religion, where the voices of women are often silenced or not made provision for because of the processes involved. The contributed organizations fully support the prohibition on child marriage. The Civil Union Act places the marriage age at 18 years and does not allow for minors to enter civil union, even with the consent of their partners or ministers of home affairs. We note also implications for legal gender recognition and forced divorces on page 23 to 26 of our written submission. And note here that the marriage bill does not address how existing marriages in terms of the Marriages Act, Civil Union Act, and Recognition of Customary Marriages Act will be dealt with, where Act 49 is invoked under the new framework. It merely states that the marriage will continue to be a lawful marriage without dealing with the implementation context. The capturing of that relationship on the internal information technology and admin systems of the department, however, will be an issue in terms of the department's policies and protocols. So the question there for us here is, how will existing marriages be dealt with practically from the perspective of the Department of Home Affairs, internal registration systems, and the capturing of information on the National Population Register? The bill does not speak to the continued challenges that transgender and intersex persons are experiencing with the current home affairs systems of recording information. And so in order to avoid uncertainty, it would be more prudent to include a section in the marriage bill under registration that echoes the protection of Act 49 of 2003, stating that a marriage registered with the Department of Home Affairs and captured on the National Population Register shall remain valid and legal regardless of an alteration of gender markers of any party. A party's gender marker shall not be captured as part of their identity in a marriage, except if they indicate that they wish for it to be captured. In conclusion, thank you, Chair. We would conclude now in the submission. We draw the attention to current aspects of the marriage bill that remain discriminatory and exclusionary, which we ask the Portfolio Committee to address. These include, among others, that the bill in its current form allows some marriage officers to object solemnizing marriages, makes provision only for polygamy and while not recognizing the full diversity of polygamous marriages, fails to make clear provision for transgender and intersex persons whose gender markers have changed and who require continued recognition for their marriages under their new personal details. It also fails to provide for the option not to capture gender should spouses wish to not have their gender captured, and uses language that is not gender neutral and excludes non-binary persons and is therefore not inclusive of gender identity. We welcome a progressive and inclusive marriage law rather than the current unequal and othering of a separate civil union act and the broader fragmentation of marriage regimes in South Africa. This committee has an opportunity to deliver true marriage equality, one that is unified, inclusive marriage act that respects our constitution promise of dignity for all. Let's not repeat history by creating new forms of separation and discrimination. In the prospective dispensation of a single marriage statute that seeks to create greater imbalance and harmony for all who wish to access it. I would like to thank the Portfolio Committee for the opportunity to provide this oral submission on behalf of Triangle Project and Women's Legal Center. My colleagues on this call may also assist with answering any questions arising from the presentation or written submission. Thank you, Chair.
Thank you very much for the presentation. I think members have noted issues which were raised and also the issues that the Home Affairs may need to comment on. Can I now invite Freedom Religions South Africa? If they are in the meeting.
Yes, thank you. Good morning, Chairperson, Honourable Chairperson, Honourable Members. May I please just, the host has disabled screen sharing. Will Mr. Matonsi be sharing our presentation?
Yes, yes.
Okay,
yeah, thank
fantastic.
You.
Just want to show my face. There I am. All right. So let me just get my things ready and then we can start. So the next slide, please. And then the next slide. Yes. The next one, yes. Yeah, that's the right one. Okay. So freedom of religion.
Just to disrupt you. At the time we started, were you in the meeting?
No, I was not. I only managed to join later.
Okay. We've allocated 10 minutes per presenter so that to allow engagement, because we're still going to receive your presentation. But we're not saying that we're suppressing the submissions.
No, perfect.
I'm just giving you the records of where the minutes how we started them. Thank you. Proceed.
No, thank you, Chair. Completely understandable, Honourable Chair. So, Freedom of Religion South Africa, we are a faith and politically neutral legal advocacy organisation, and our mandate is to impartially uphold the right to religious freedom and related rights in South Africa within the framework of the Constitution and the democracy and the rule of law. And we have a very diverse support base of millions of people of various faiths, and many of them include religious marriage officers. Next slide, please. So just a bit of background, we've been an active participant in this process from the Green Paper to the White Paper to the Department's extensive public consultation processes, which was very well done. And we also commented on the draft marriage bill. And of course, we recognize that there are failures in our current fragmented regulatory system, which includes the non-recognition of religious marriages, and there is a need to address any discrepancies. Next slide. So we support the rationalizing of South Africa's marriage laws to ensure that all people are treated equally and with dignity. Our interest in the bill is limited, though, because we have quite a narrow mandate, and it's limited to those aspects that impact the right to religious freedom and related rights of religious marriage officers and the organizations they belong to, as well as ex officio marriage officers. Next slide, please. So the white paper on marriages forms the basis for the bill. We think that overall it's a very good white paper, very balanced policy positions for such a diverse society such as South Africa that can reasonably accommodate all members of our society. And we think in large that the bill complies with this white paper, but we believe there are also aspects of the bill that can be improved so that the bill can fully comply with the Constitution, the white paper, and international law. So what do we specifically support? We support the broadening of the scope of who can become a marriage officer, because this will allow members of all groups in society, whether they're religious, whether they're cultural, whether they're secular groups, to have their own marriage officers who can serve the needs of those communities so that nobody's left out. And we also support that the white paper makes provision for all religious formations to have their own marriages who are able to solemnize marriages according to their particular religious convictions, their creeds, and their practices, while at the same time observing the marriage legislation. Next slide, please. Next slide, please. Thank you. We also support, support that the white paper makes provision for all social groups, as I said, to have their own marriage officers who can solemnize their relationships in line with their particular worldviews and value systems and practices. And we also, the white paper also says that, they provide for ex officio marriage officers not to perform any ceremonial functions. So the white paper's recommendation is split the administrative legal functions that you just do to register a marriage or a union from the more ceremonial religious functions. So it separates the state function from the more cultural and religious functions. Next slide, please. Okay, the slide after that. So when it comes to the protection of religious marriage officers and their organizations, we're very glad that the bill does protect them, that they cannot be forced to solemnize any marriages that go against their particular convictions. This, of course, is in line with freedom of religion in a diverse society such as ourselves. Our Constitution also contemplates that we need to find ways to accommodate everybody and protect rights. And this protects the freedom of religion. This, of course, is also in our current Marriage Act, and we are grateful that the bill includes this protection expressly, and we support that it will continue in future. Next slide, please. An area of concern for us is that this protection is not extended to an ex officio marriage officer, that they don't have a right to conscientious objection. Of course, we say that recognizing that that the state has a responsibility to equally and fairly to provide marriage and services to everybody who's allowed to marry with or go into a union or partnership in terms of South African law. But as the white paper has as a very good recommendation, if you split the ceremonial functions from the administrative legal functions, you'll be able to get a system where nobody is forced to do anything that violates their conscience. In that way, protects the dignity and equality of all people. Going to specific submissions, you can, just for the sake of time, I think just go to the next slide. Just next slide, please. And then, yes, just the one after that, religious marriages. So we welcome and support the inclusion of clause 3 and its particular subclauses, which provides for the equal recognition and legal protection of all religious marriages, because if those marriages are not recognized, obviously the spouses and the children are at a disadvantage. Next slide, please. We also welcome and support, as I've alluded to, that all groups, cultural, secular, traditional councils, Khoisan councils, religious institutions, they can all have their own marriage officers who are able to perform marriages, ceremonies, unions, in terms of what that particular group sees it as, and then everybody in terms of their own group and their own community can enjoy the equal benefit and protection of the law. Yes, designation of marriage officers. Just gonna note, next slide, please. And the one after that. Thank you. And also, as I've alluded to, we welcome and support the inclusion of Clause 11.4, which upholds the right to religious freedom of religious marriage officers, and per extension, their organizations, which protects them from solemnizing marriages that go against their conscience, religion, and belief. Obviously, this is very important for the protection of religious freedom, which is also an equality right. And this is similar to Section 31 of our current Marriage Act. Next slide, please. We believe that this will help ensure that the bill complies with the Constitution and international law, that even though it is a form of discrimination, it is a form of fair discrimination, and especially since other groups can now have their own marriage officers, and if the state can, provide services equally to all, then there is a way to accommodate everybody. And this protection was also, the rule rather than the exception when you look at most African and Western countries. Next slide, please. The next slide is just a quote taken from the Fourie case, which acknowledged the right of same-sex couples to enjoy the same status, entitlements, and responsibilities as heterosexual couples. But the court noted that this is in no way inconsistent with the right of religious organizations to continue to refuse to celebrate same-sex marriages, and that the two sets of interests involved do not collide, but they coexist in a constitutional realm based on accommodation of diversity. And that's very important, the accommodation of diversity. Turning to the ex officio marriage officers, we believe that this provision can be improved by differentiating between solemnization, which is, more a ceremonial aspect, from the formalization, the legal administrative aspect. The bill can be improved by saying that ex officio marriage officers, they only formalize marriages, and this is in line with what the white paper recommends. They don't solemnize, they formalize. So it's the same as somebody is registering a birth or they're registering a death. They're just registering that this has happened. And if you insert definitions also for formalize and solemnize to distinguish between these two, and that takes away any, that should be able to deal with any conscience objections while enabling the state to give equal service delivery to all people. Next slide, please. Yes, as I've alluded to, this is what the white paper says, and it's a welcome separation of the functions of the state and those performed by religious ministers or cultural or other persons who represent secular organizations or cultural organizations or traditional organizations. The state should be concerned with ensuring that there is a legally valid marriage, that there's consent, and the parties are who they say they are, and it's duly registered. Next slide, please. We believe that the way it is worded currently, it does compel these ex officio marriage officers to solemnize any marriage, and we believe that the right of freedom of religion within our constitutional framework that celebrates unity and diversity, not unity and conformity, is wide enough to protect also those, that if you're a person who holds certain religious beliefs or secular beliefs, cultural beliefs, that you don't leave that at home when you go to work in the morning. But in our framework, as I've said, we can find a way to accommodate everybody so that the state also performs its duties and functions equally to all people without undermining dignity or equality. I think for the sake of time, I think we can move along, because this all is in our formal submissions as well. If you could just perhaps go to the next slide. I think there's our recommendations to amend the clauses to say that, religious, cultural, secular marriage officers or people belonging, for example, to a custom, a tribal council, something like that, they can solemnize marriages because they're performing rites and rituals. However, that your ex officio marriage officer is just doing this because it's a function of a job that they're employed to do. They formalize marriages at the Republic, within the legal framework. And the next slide, we've just there we have definitions for formalized and solemnized, just to distinguish between the two, to make the text of the bill, to make sure it's sound. Next slide. Next slide, please. There's just another quote from the Fourie case that says the fact that in an open and democratic society contemplated by the Constitution, all the rights of non-believers and minority space must be fully respected. Religious beliefs held by the great majority of South Africans must also be taken seriously. The next slide, please. And this is also taken from the very judgment, where the court just emphasizes the recognition of the constitutional value of acknowledging diversity and pluralism, and the right to, freedom of association. And this stresses the importance of trying to protecting people's right to be different. And that goes for all people, their right to be different, and how we can accommodate everybody in our society that way. All right, I think that you can move on to slide 31, Mr. Matonsi, please. There is one aspect of the bill that it's a bit of a technical aspect, perhaps, and that might lead to the unintentional criminalizing of a religious leader. Now, we don't believe that this is the intention of the draft whatsoever. We just think this is technicality that can be improved. This is the situation where you have a person who is, maybe they're a religious leader, and they perform a marriage ceremony, but it's the ceremonial parts. And this religious leader, they're not a marriage officer, but the couple getting married, they understand that this person is not a marriage officer. So they will have another religious marriage officer there or a real religious marriage officer is duly registered to register a marriage, to solemnize it. Or they will might have gone to the Department of Home Affairs, and they understand that it's only the RMO, the religious marriage officer, is duly registered, in terms of the legislation, or the person, the marriage officer at Home Affairs, who can actually contract their legal marriage. But they have another religious leader who is just there doing the ceremony. And the purpose of this recommendation is just merely to tighten up the wording of this clause so that these people who just do the religious ceremony parts, but they're not the person who asking the questions and filling in the register, that they are not inadvertently criminalized, obviously subject to the couple and knowing, and this person not misrepresenting themselves. So these are just recommendations for that, but that is also more fully available in our written submission, where all of this is put out in a little bit more detail. And I think that brings us to the end of my presentation. Thank you so much.
Thank you very much. Thank you very much for the presentation and the issues that were raised. I think members are taking note, and Advocate Malekate will now invite Stellenbosch University. Thank you. Mr. Matonsi, earlier on, the prof was in the meeting.
Yes.
Okay, thank you.
Thanks for having me. I must emphasize I'm not speaking on behalf of the university. I'm speaking as an expert on family law. I've been teaching family law and law of marriage since 1966. I'm the co-author of the Matrimonial Property Act of 1984 and also an author of the Divorce Act of 1979. So I'm talking as an expert on family law and the law of marriage. If we could have the first slide, please. You cannot separate the present bill, of course, from its history and the history of marriage law in South Africa, and also from the fact that we are a very diverse society. Especially in the field of religion, we're extremely diverse. According to the most recent census, 85% of our population regard themselves as Christians, of which many are members of African independent churches. Then there are about 8% who are traditional African religion adherents. There is about 1.5% Islam and about the same number of people with a Hindu belief. So it's a very, very diverse group, but with a strong Christian majority. And this is reflected in our history. I'm not going to go into the whole history, but the fact is that the marriage law in South Africa arrived here with the Dutch settlement, became part of Roman Dutch law, was strongly influenced by English law in the 19th century. And then we came to the 20th century and the 21st century in particular, where in the third last point here, we had major changes because of the new constitutional dispensation regarding monogamy, differences in gender, and the fact whether marriage is still a lifelong bond, as it used to be seen in the Middle Ages. I'll concentrate, not necessarily in a particular sequence, on the problems in the present bill. The next slide, please. I agree and strongly support the objects of the bill, which are to have a single bill regarding the formalities for marriage, applicable to all marriages in our country. But there are major problems in my regard, in my view, in the present bill. First one I want to mention, which I want to eliminate as a problem, is that the fact that the bill restricts polygamy to male spouses and does not allow polyandry as it's known. That is a multiplicity of husbands for a wife. Polyandry is extremely rare on Earth. Only in the foothills of the Himalayas, in certain parts of Tibet, there are some small tribes who practice this form of marriage, and it's closely linked to land ownership and the ability to keep agricultural land in a family, with a woman marrying two brothers at the same time. There are people, I've heard one of them this morning as well, who say that this is discriminatory. I think that in terms of section 36(3) and 39(1)(c) of the Constitution, this is a reasonable distinction, because there is no need, as far as I've ever ascertained, for people to have polyandry in South Africa. And the overwhelming majority of systems all over the world restrict multiple marriages at the same time to polygamy and do not allow polyandry. So I don't feel that is unreasonable. My real problem is Chapter 6, which in my view doesn't belong in this legislation at all. The Department of Home Affairs has no jurisdiction over the matters mentioned in Chapter 6. Matrimonial property law, the law of divorce, and the dissolution of marriage are all matters for the Department of Justice. And I do not see how these proposals could end up in the bill. As far as the matrimonial property law side is concerned, proposal in section 50, clause 15, is particularly disturbing and totally uninformed. It abolishes the idea of a so-called legal matrimonial property regime, namely the default system which one finds in all legal systems, which deals with the matrimonial consequences of marriage unless the parties to the marriage agree otherwise. Now, according to this proposal, clause 15.2, each marrying couple would have to make an individual decision every time there is a marriage. Now, this is totally unpractical. Who's going to help them make this decision? It's based on incorrect assumptions about matrimonial property law, and it would make South Africa unique in the world, particularly when our private international law, conflict of laws is concerned. It just cannot work. You must be able to assume that in China or Paraguay or in Peru, there is a default matrimonial property system, and the same in South Africa. At the moment, it's universal matrimonial property, community of property, and it will probably remain like that for a long time. And therefore, the whole of Chapter 6 should be eliminated from the bill. In any case, it's not part of the remit of the Department of Home Affairs. Then another smaller problem, clause 4, I think it's wrongly placed. It deals with the proof of identity of the spouses. It should rather be placed in Chapter 5 of the bill. That's a fairly technical issue. The third fairly curious provision, in my view, is clause 5.2, namely a curious proposal which I cannot see the reason for and which may infringe the principle of religious freedom, namely to say that it must be negotiated and entered into or celebrated in accordance with the respective custom or religion. That goes for itself. I don't know why this clause is necessary. A more substantial issue is the question of the minimum age for marriage. Now, I've read in the papers that there's been, in other hearings, concerns about it being 18 and even proposals that it should be raised, the minimum age for marriage, to 21. That does not make any sense. A few years ago, the general legal minimum age of majority was reduced from 21 to 18. I didn't think it was such a good idea, but that's not important. The fact is, it was reduced. You cannot have an age for marriage at 21 and allowing people to sell their homes, enter into any other contract at the age of 18, but not allow them to marry. Therefore, you cannot, as far as I'm concerned, lower or increase the age of marriage beyond the present 18. What I do worry about is that in terms of the present Marriage Act, Section 26, there is a possibility to apply to the Minister of Home Affairs to be able to marry if you are below the age of 18. And the present bill doesn't provide any qualification like that. Now, it's a reality. Young people will have sex. There will be little accidents. And if a young couple at the age of 17 for the man and let's say 16 for the woman happen to fall pregnant, are they supposed just to remain unmarried in spite of the expected reaction of the communities in which they live? I don't think it should. I think this is an example where the Department of Home Affairs finds this a very inconvenient rule. The present one, they must have thousands of these applications every year. It's a nuisance to them, and so they want to get rid of it. There should be some replacement for it. I don't think the possibility of replacing of consenting in those circumstances should necessarily be at a ministerial level. It's far too high, but perhaps it could be delegated to magistrates, local magistrates, or other government officials to allow them to give permission for marriage at an age below 18. It's, I think, urgently necessary. There are some other wording problems. For example, in clause 8.3b, there is, as far as the designation of marriage officers is concerned, it's said that you can have a marriage officer from a secular organization as well. That is an extension from the present position. I don't know what a secular organization is, and we should definitely have greater clarity in this regard. Does it mean a bartenders association, secular association? I don't know. Then what I do miss as well regarding designation of marriage officers, shouldn't there be a register of marriage officers which is open to public view? How on earth am I to know as a member of the public who is a marriage officer if I'm wanting to find one, for example, for the marriage of my daughter? Next one, which I find more serious, is the proposed reintroduction of marriage by proxy. Huwelik met die handskoen, die goeie Afrikaanse term, wat kom van die tyd toe mense 'n handskoen gestuur het na jou bruid en die handskoen jou verteenwoordig het. This possibility, which existed all over the world, was abolished in South African law in 1960, and for obvious reasons. In modern days, people can travel, they can fly from one end of the earth to the other end of the earth in a day. Marriage by proxy was something which came from the days when you took months to get from one place to another. And there could be possibilities, for example, the bride sitting in Holland, the bridegroom sitting in Cape Town, and there was a possibility the bridegroom could die before the bride eventually gets to Cape Town after 3 or 4 months. And then you could have a marriage by proxy, which would serve a useful purpose. I don't see any reason why in the modern times with modern communications, etc., there should be a revival of marriage by proxy. And I think in any case, you may have a problem with clause 11.6, which seems to presuppose that all the people are present at the wedding. A practical issue as far as I'm concerned, can the Department of Home Affairs cope with clause 13.5's compulsory registration? Because it's now proposed that all marriages, even the existing ones, which haven't been registered, should be registered in the future. Very laudable, but can they really cope? I have my doubts. Then there are, of course, positive aspects as well. I'm not an expert in traditional African law, and therefore I'm not a real expert on polygamy as well. But from a modern point of view, I welcome the clear requirement in clause 6.2 that the husband in a polygamous marriage should get the consent of the first wife when he wants to take another wife. It's in any case something which is being required by the courts in terms of their powers. But here I'm very doubtful. So-called royal families, why are they excluded from this consent requirement? I don't think this is possible in terms of our the equality requirements of our constitutions. I also, secondly, say I don't think a prohibition or continued non-existence of polyandry is desirable. It's a theoretical equality issue, but in practice, it plays no role whatsoever. Then finally, on the formalities for marriage, I think this is a great improvement, what's proposed in the bill. The old Act of 1961 has all sorts of funny provisions, for example, to give each other, the couple must give each other the right hand, and then there are certain words which must be spoken by the marriage officer, etc. And often in class one asks the obvious question: what happens if one of the spouses doesn't have the right hand because he'd lost his right arm? Can the marriage then be regarded as valid? Obviously it can, but nevertheless, I think it's silly really to come with those sort of detailed prescriptions, and I welcome the abolition of those prescriptions. Then finally here, the whole question of conscientious objection by marriage officers. I support the proposal in clause 11.4 that religious marriage officers should be able to refuse to enter, for example, to conclude a marriage, or officiate, sorry, over a marriage between people of the same gender, because I think it's part of a freedom of religion, which is guaranteed by our Constitution, to allow those people to have those objections. Finally, the road ahead. I don't think the present bill can proceed. There are far too many problems still. Chapter 6 in particular should be removed, and it's for this committee, obviously, to decide how they are going to handle the road ahead. This is a good start, the bill, but nothing more than that. Thanks a lot, Chairman.
Thank you very much for your contributions, and it will definitely assist our work as other presenters have made their contributions. I've noted that you are not representing the university. I think I must just put it on record. I was just sequencing my easy in terms of inviting a participant to the meeting.
Thanks a
We'll
lot.
now move. We'll skip the questions for now, and the response from Advocate Malikat. I'll invite Free Society Institute. Okay, they seem not to be in attendance. Can you proceed to another? Al-Jama, United Alma Council of South Africa. Okay. They seem not to be in the meeting. Can now proceed to Al-Jama Political Party.
Can you unmute me, please? I seem to have a problem
I'm
now.
in the meeting.
Yeah. Sorry.
Can I establish the status of your...
My name is Ismail Mohammed, and I represent the United Ulama Council.
Oh, okay. It means you're muted. Thank you very much for joining us. You can now proceed.
Okay. Good morning, everybody, and assalamu alaikum wa rahmatullahi wa barakatuh. My name is Ismail Mohammed, and I am the legal advisor to the United Ulama Council of South Africa. And I am here today to represent the United Ulama Council of South Africa. The United Ulama Council of South Africa enjoys a wide confidence among the Muslim community in South Africa, and its membership stretches across all 9 provinces in South Africa. So my submission today will show that the bill that we have before us that we are talking about today will not comply with the requirements of the Constitution and will not comply with the order of the Women's Legal Center Court, in that the Women's Legal Center Court has ordered that the non-recognition of Muslim marriages is unconstitutional, and it is submitted by the United Ulama Council of South Africa that this bill does not absolve the government, or this bill does not fulfill the order that that court has placed on government. So let me start by saying that the courts have in a number of cases declared that the non-recognition of Muslim marriages is unconstitutional. And the Constitutional Court in the Women's Legal Center Trust case declared that various sections of the Marriage Act, the Divorce Act, as well as the definition of the common law of marriage are inconsistent with certain sections of the Constitution, because they fail to recognize Muslim marriages and they fail to regulate the consequences of such marriages. The question that we have to ask at the outset is that what is a Muslim marriage? Most people, as well as this bill that we are discussing today, make the mistake to define a Muslim marriage as a marriage between 2 Muslim persons. This is a mistake. Not because I say so, but because the Constitutional Court said so. So at the moment, so without any legislation, Muslims marry in a mosque before an imam, and that is a Muslim marriage. Then they marry at home affairs, and that is not recognized as a Muslim marriage. So we submit that this situation will continue even under this bill. And the reason for that is the definition that the Women's Legal Center Court placed on what a Muslim marriage is. The Women's Legal Center Court defined Muslim marriages as marriages solemnized in accordance with Sharia law. The court then ordered the president. So it is important to take note of this, that the court did not define a Muslim marriage as a marriage between 2 Muslim persons. It defined a Muslim marriage as a marriage solemnized in accordance with Sharia law. The court then ordered the president, cabinet, and parliament to ensure the recognition of Muslim marriages. This legislation, the court continued, must recognize Muslim marriages, that is, as solemnized under Sharia law, that marriages solemnized in accordance with Sharia law for all purposes, and it must regulate the consequences arising from such marriages. It is submitted that the bill is devoid of any religion. This bill that we are talking about today is devoid of any religion, neither Islamic religion or any other religion. The religion that forms part of marriage in Islamic law, the religion that forms the substratum of a Muslim's God consciousness, is entirely ignored by this law. This bill treats Muslims as if their religion and their religiosity is simply to be tolerated and not actually recognized. Therefore, it is our submission that the bill is written with the intention to accommodate all religions under a single act. However, what it has achieved is to accommodate no religion under the act except atheism or secularism. The bill, therefore, impairs the freedom of religion rights of Muslims to marry and divorce as Muslims. It forces Muslims to marry and divorce under a secular law, and it constrains Muslims from marrying and divorcing under legislation recognizing Muslim personal law. In this context, when Muslims do not act in accordance with Islamic law, they act contrary to Islamic law. What that means is that when a Muslim marries or divorces not in accordance with the Sharia or Islamic law, then they are in fact acting contrary to Islamic law. The consequence, therefore, when Muslims marry or divorce in a secular manner, a manner devoid of religious values or ritual, they are in fact acting contrary to their religion. The consequence of this act by the government is therefore to coerce or constrain Muslims from acting in accordance with their obligations under Islamic law. The measures taken by the government here, by the enactment of this bill, impairs the Section 15 and Section 31 freedom of religion rights of Muslims. Marriage is contracted on an individual basis. In that two individuals conclude a marriage, the bill denies these individuals the right to marry and divorce under a law of his or her religion. In this act of denying individuals under Section 15(1) of the Constitution, the whole community is denied their freedom of religion and rights under Section 31 of the Constitution. This act of denial by the state is the removal of a brick from the edifice of a Muslim's life, Islamic life, and the beginning of killing off the community as a whole. Perhaps it is felt by the listeners that this language by me may be overdramatic. In this regard, Judge Sachs in the Christian Education Court, in his evaluation of the text of Section 31 of the Constitution, said, "The rights protected by Section 31 are significant, both for individuals and for the communities they constitute. If the community or communities dies, whether through destruction or assimilation," it is important that we take note of this word, assimilation. Whether through destruction or assimilation, there would be nothing left to respect of which the individual could exercise associational rights. Moreover, if a society is to be open and democratic in the fullest sense, it needs to be tolerant and accepting of cultural pluralism. These are the words of the judge of the Constitutional Court. At the same time, the protection of diversity is achieved indirectly through the double mechanism of positively enabling individuals to join with other individuals in their community and negatively enjoining the state not to deny them the rights to collectively profess and practice their own religion. Taken together, the judge says, taken together, they affirm the right of people to be who they are without being forced to subordinate themselves to the cultural and the religious norms of others, and highlight the importance of individuals and communities being able to enjoy what has been called the right to be different. It is envisaged that all South Africans will marry and divorce under this law. Intended or not, This coercion of Muslims and others to marry under the bill will cause the eventual death of Muslim life in a community through their assimilation under this law. It is submitted that this coercion is not unity in diversity. It is unity by force. There is no diversity in this law. This law is supposed to recognize all religions, and yet it does not recognize a single religion. There is no diversity in this law, and yet our constitution ensures unity by diversity, not unity by unity. An open and democratic society requires respect, acceptance, and tolerance of all religions. These cornerstones of democracy and the right of Muslims to practice their religion as a community, as guaranteed under Section 31 of the Constitution, is achieved by enabling each individual to join with other Muslims to marry and divorce under legislation recognizing Muslim personal law, and to ensure that the state does not deny them individually and collectively the right to practice their own religion. Judge Sachs then brings all these community rights together by saying they affirm the right of people to be who they are without being forced to subordinate themselves to the cultural and the religious norms of others, and highlights the importance of individuals and communities being able to enjoy what has been called the right to be different. It may be argued that the denial of a substantially Muslim marriage law will result in the killing off of the Muslim community by its assimilation into the broader society is far-fetched. However, the Lawrence case is in fact a monument to such an event. The Lawrence case argued that the imposition of a ban on the sale of alcohol on Sundays is imposing Christian values on non-Christians, because Sunday is a Christian holy day, or the Christian Sabbath. The court agreed with this argument. However, on the facts, the court found that Sundays has lost its Christian qualities. Sundays was no more regarded as a Christian day or the Christian Sabbath. The court said that Sundays had acquired a more secular nature. This is precisely what Judge Sachs means when he speaks about the death of a community. It may be a few generations before Muslim marriage loses its Islamic qualities and acquire a secular nature, just like Sundays have acquired a secular nature. That is precisely the purpose of constitutional controls, to prevent governments from enacting seemingly innocuous, but on proper reflection, clearly insidious legislation. It cannot be gainsaid, it cannot be argued that the enactment of an entirely irreligious bill results in an atheistic and secular law. It can further also not be argued that this bill is just that, a law without religion. Constitutional law scholars have for many years regarded atheism and secularism as religions, or more precisely, as belief systems. In South Africa, this is particularly the case in the sections 15.1 sense of the meaning of religion. UXA submits that the enactment of the bill will result in enacting a secular law and an atheistic law intended for religious people. Such enactment would indeed result in the explicit endorsement of one religion or belief system over others, because it would provide an inequitable and unfair preference of secularism and atheism over other religion, and would therefore not be constitutionally permitted. To summarize this section, we have demonstrated that the preambulatory principles of South Africa's constitution lay the foundation for everyone who lives in this country to feel at home in it and to live their lives freely and without being made to feel that they are aliens of the law. We have further shown that under apartheid, Muslims have been regarded as illegitimate, and this position has been allowed to be by the democratic government to continue. We followed this with a discussion of the relation between Muslims and God and God's law. We showed how South Africa's marriage law metamorphosized from a religious-based law to a secular law. We demonstrated that the Constitution, and in particular Section 15 thereof, obligates government to enact legislation recognizing and reflecting Muslim personal law. We then showed that the courts, and in particular the Constitutional Court, also interpret the Constitution as saying that government must enact legislation recognizing marriages solemnized in accordance with Sharia law, as well as its consequences. We then showed how the bill fails to comply with these constitutional obligations, and that in fact it hinders Muslims in the exercise of their basic human rights enshrined in the Constitution. At the moment, so in a way forward, what at UXA level, it is our position not to say that marriage law must be in accordance with Islamic law. It is also not our position to say, as others have, that marriage law must be in accordance with the values of A religion or B religion or C religion, or that it is also not our position to say that marriage law must be completely irreligious. It is our position to say that marriage law must reflect the religion and the culture of the people who marry. And that is exactly what the Women's Legal Center Trust Court said. At the time of the decision of the court had the Marriage Act, the Recognition of Customary Marriages Act, and the Civil Union Act. The Marriage Act was designed for and by with Christian values. The Recognition of Customary Marriages Act was designed for, by, and with African values in mind. The Civil Union Act was designed for same-sex marriages. At that time, in a religious sense, Christian people were accommodated for, and African cultural people were accommodated for. No other religions were accommodated for. According to the Women's Legal Center Trust case, other religions should also have been accommodated for. And that is all the government needs to do. And what UXA says is the manner in which this should be done is that the omnibus bill, which government speaks about in its green paper, or rather Home Affairs speaks about in its green paper, should be enacted in place of this bill. And the omnibus should look like this, that there should be a chapter for marriage officers, a chapter for age regulation, a chapter for other administrative stuff. And then there should be chapters like the Marriage Act. There should be chapters like the Recognition of Customary Marriages Act, chapters like the Civil Union Act, recognizing the vast diversity of the peoples of South Africa, which is in the Constitution, which says unity in diversity. There should be a chapter enshrined with the Islamic values of marriage, just like the Muslim marriages bill published by government in 2003 and in 2011. There should be a chapter with something like that. Then should be chapters for the religious values of other people if they so wish to have it. This is unity in diversity. At the moment, what we have is not
Mr.
unity
Mohammed,
in diversity.
Mr. Mohammed, you must work towards summarizing your submission.
Okay, thank you, sir. I will do so in 1 minute.
Thank you.
UCSA's submission is that this bill is rejected and opposed by UCSA. And we propose, as we have since 2022, a omnibus bill in which there is a particular chapter that reflects the values, marriage values, and divorce values of Muslims, that it will be in accordance with the order of the Women's Legal Center case that says that government must bring about law for Muslims that solemnizes marriages in accordance with Sharia law. Thank you very much.
Thank you very much, Mr. Mohammed, for your submissions. Thanks. We'll now invite Al Jamaa Political Party.
Good day, everyone. Thank you, Honorable Chabani. My name is Muhammad Harun. I am the National Chair of Al Jamaa, and I'm representing the party at this particular forum. Before I sort of just read this, my sort of oral presentation, of course, I just want to make 3 points as a preface to this. One, I think as you have just heard the UCSA representative advocate Mohammed just outlining, the UCSA as well as previous theological bodies before UCSA came into being had made many attempts to have Muslim marriages recognized. This has been way back in the 1980s, towards the late 80s, and one of the individuals who really led that particular process was Advocate Hafiz Abu Bakr, who later became judge. Of course, he has since retired from that. But the point which I want to make is that there's a long struggle that had been undertaken with the hope that Muslim marriages would be recognized. So, of course, fast tracking, we go into the 1990s and 2000s, we find that much effort had been made to really ensure, and like Advocate Mohammed just mentioned, in 2000 and sort of early 2000, there was a sort of the whole attempt to have this sort of recognized, but unfortunately, for various reasons, this could not be or didn't happen. The second point I want to make is that, of course, the party that I represent came in only in 2007, and because of the president's party having been involved in labor law and in other sort of matters, he felt the need maybe to take up this particular issue through the parliamentary system, using the private members' bill avenue to basically ensure that something really comes of this. So, in other words, what the party's been doing is building on what others were unable to really successfully achieve, and this is where we are. Bearing that in mind, and allow me just to then read what has been put on the screen. I'm representing Al Jamaa Political Party and its Limpopo members, and the oral submission that is being made today is presented with the full support of my party. So, Honorable Secretary of the Portfolio Committee and Home Affairs, I wish to thank you for the kind invitation to participate and present at this oral public hearing related to the marriage bill. I want to, however, bring to your attention that during the sixth parliament, my party, Al Jamaa, had on the roll a record of the PMB, Private Members Bill, that was called the Muslim Marriage Bill. This MMB has had a first and a second reading in two respective parliamentary debates in Parliament. It was, moreover, referred to your esteemed committee. Now, while the PC was scheduled for a report to Parliament, my party was approached by the committee chair, the then Minister of Home Affairs, the Speaker, and the Chair of Chairs to withdraw the MMB to allow the presentation and the passing of the current comprehensive marriage bill. and avoid confusion in forthcoming public participation. As you all know, there was a constitutional court case that pointed out that the Marriage Act must be amended and it should comply with the following judgment. And I quote, "The Marriage Act 25 of 1961, inverted commas Marriage Act, and the Divorce Act 70 of 1979, known as the Divorce Act, are inconsistent with sections 9, 10, 28, and 34 of the Constitution in that they fail to recognize marriages solemnized in accordance with Sharia, that is, Muslim legal system, which have not been registered as civil marriages, as valid marriages for all purposes in South Africa, and to regulate the consequences of such recognition," close quote. And the deadline for this was on the 26th of June 2024 to make sure that the Portfolio Committee and Parliament observe the deadline. And this is to make sure that it was not in contempt of court. This bill must comply with this judgment that was issued, and of course sections 9, 10, 28, and 34 of the Constitution. In this regard, my party assisted the Department of Home Affairs by making the necessary provisions. It did so by issuing a South African Muslim marriage certificate. This was towards the end of 2024, by way of 2 circulars, which is included in the submission, that can be obtained from the Department of Home Affairs. As soon as the Minister of Home Affairs, then Minister of Home Affairs, of course, published the circulars in the Government Gazette, he emailed the Ministry, Parliament, and President to comply with the constitutional order. It was agreed by the then Minister of Home Affairs, and in turn supported by the Chair of Chairs, that these regulations and the heart of the registration of the MMB, that is the Muslim Marriage Bill, be accommodated in the Marriage Act. Now, this deal was applauded by the Speaker of Parliament at a program meeting. It was also personally applauded by the Chair of Chairs at a meeting where my party was also represented by the Member of Parliament, Honorable Hanif Hendricks, who of course is the president of the party and who has since been appointed as Deputy Minister of Social Development. The provision for a South African Muslim marriage certificate has assisted many women to get their right in terms of Sharia marriage law. Muslim women have applauded this, as many men and their in-laws have denied them these rights using the absence of the nikah registered on the National Population Register. Recently, my party's leadership met with the Home Affairs Director General and his head of policy. It was explained that this oral submission that my party, in this instance, I am presenting to the PC, is expected to accommodate the agreed deal, a deal that was made between Al Jamaa's party's legal representatives and the Home Affairs legal team at the behest of the former Minister of Home Affairs. Related to this, we have sent a full written submission in draft 2 to your Secretary, Mr. Ede Matonsi. For your information, Al Jamaa has its provincial head office in Limpopo, Zanin, where it has a constituency. The latter, for the record, gave its full support for the submission, and they look forward to express their views. My party, therefore, looks forward to the consideration of the official party submission that is supported by its MP, Honorable Imran Musa, and my party would like to bring to your attention that its preferred definition of the concept of Sharia has been incorporated in the amendments of the Divorce Act, Government Gazette, number 689, 18th November 2022, number 47526 clause. And I read, Muslim marriage means a marriage concluded in accordance with Islamic law, of course, Sharia, that is Sharia, which regulates all public and private behavior as derived from traditional customs known as al-urf, the Arabic word, the two primary sources, namely the Quran, which is the divine word of God, and Sunnah, the prophetic practices of Prophet Muhammad, and the uses of juristic tools such as ijma, meaning consensus, and of Muslim jurists. In other words, those individuals who are able to issue legal opinions, and the individual jurists, qiyas, analogical deductions to issue legal edicts. So it is therefore a constitutional requirement that this also be accommodated in this bill. In the event of Parliament going for an omnibus bill, the chapter relating to Muslims must accommodate our withdrawal bill, withdrawn from for the sake of compromise and cooperation, the registration of Muslim marriages bill. So in our written submissions, we have also introduced an opt-out clause. And then, of course, we indicated that the age of marriage is a contentious issue, as marriage certificates assist with human trafficking. Now, of course, this relates to a point that Professor Van Wyk also had raised. And so that can be elaborated upon further, but it's just a point we're trying to make. We hope that this African marriage certificate only be issued when both spouses reach 18 years. So the issue of age was also raised early on, but that religious and customary customs prevail in the case of Muslims. This union, which is known as a nikah, and upon registration becomes a marriage to comply with South African National Population Register. Alongside this oral presentation, of course, we have written texts that have been appended. The written one is a public participation written submission of the party. And then in addition to that, the copy of the marriage bill annexure, MB1, with proposed amendments in the bill in red and commentary to the bill in blue. So we've tried to basically include all these comments pertaining to the current proposed marriage bill as such. And so those ideas need to be taken on board. The third was further options that can be considered. So we tried to also write out a few points that we thought need the committee's attention. And then we have basically two circulars, the one complementing the other. In fact, the circular 11 basically of 2023 basically has been beefed up with the subsequent one. So that was the idea of complementing and tightening up issues that perhaps we have maybe overlooked at that time. So to accommodate, and of course all of these to accommodate all religions, we attach a draft bill, recognition of religious marriages bill, in our written submission. And for the sake of comprehensive submission, we also attach draft bill for Sharia marriage court. Both must be seen as further options. And just as I wind up, Chair, is that I think we need to then look at different options so that we do not restrict. And I think as the former sort of our previous colleague had said, of course, if there's an omnibus bill, and of course we try to make that point here, is that this be accommodated as a whole. And I think that would be one way in terms of being more accommodative, considering our diverse backgrounds, considering different communities that we're trying to serve. And of course, we ourselves know that it's no easy task, partly because there are different legal opinions, even amongst within the Muslim community, as you yourselves know, we have different opinion as to whether to legislate or not to legislate. I mean, these are internal discussions that have been unfolding and taking place over the many years. And of course, there has been no set agreement on some of these, although there's a degree of understanding and appreciation of why some feel it should be legislation should really take place in a very forceful manner, so to speak, forceful in the sense that it needs to be done because communities themselves need to observe these rules and regulations. But let me wind up and say that I think the whole process that we are sort of pursuing is we want to ensure that dignity is given to each and every family that we serve. Two, in doing so, I think we need to think of the impact of a marriage bill such as this upon the generations to come. We must not look at it just within our context that we live in the year 2025 and we only whatever we're doing is for our communities. Yes, indeed, they are, but we need to ask critical question 10 years, 20 years, 30 years down the line. To what extent is this crafted bill that we have accommodative, cooperative, sort of allowing the space for communities to exercise their rights and to be their dignity to be sort of kept intact? And will it, is the question I end off with, will it really be a negative outcome in the next 20 years or 30 years, or will it have a positive outcome? Of course, we're trying to look into the future and ask and basically try to ensure that whatever we do now should not undermine, should not impact in any negative way the communities to come. For us, I think as a community, as Advocate Muhammad underlined, of course, we want to keep our identity. We want to hold on to our cultures and to our religious identity, specifically partly because our community has been around for literally more than 300 years. And in fact, at the turn of the 20th century, there was a court case in 1902 where this issue was also raised. Of course, the whole issue of Muslim marriages itself was not recognized, as we know, in the colonial period, apartheid period. And now we're still struggling at this juncture in our lives to really have ourselves recognized. I think with those points, let me end and thank you very much for this opportunity.
Thank you very much for your contributions. We have taken note. Can now invite the last presenter, Christian View Network.
Hi there. I'm Philip Rosenthal from Christian View Network. We have been speaking up on this issue since 2003, when the proposals were first made by the South African Law Reform Commission to accommodate same-sex marriage, and which we strongly opposed at the time and continue to oppose. I'm going to be addressing the proposals in this bill firstly, and then the arguments that are being used in favor of it. And then I will be looking at the core issues in the Constitutional Court judgment, which has motivated this whole process, and what the alternatives are to address those. So if I go to first what this bill effectively proposes, and why this is going to cause social problems, which will exacerbate the existing social problems that have already been created by these undermining and attacks on marriage. The first issue is what this marriage bill proposes. There were three alternatives that were considered for this marriage law, and at the moment we have the Marriage Act, which we fully support and believe is a social good in our society, and which the state has a vested interest to promote because it promotes many social benefits apart from just to those two individuals. Then there is the Customary Marriage Act, which allows for polygamy in the case of African tradition. And then there is the Civil Union Act that recognizes what we call fake same-sex marriage. We don't consider this marriage at all. Then there is the Muslim divorce ruling, which would accommodate potentially polygamous marriages from that tradition. Now, the three alternatives that were considered previously were a Unitary Marriage Act, which we pushed as the worst option, and this is the option that is being looked at the moment. We hope that this will be scrapped. Then there's the Omnibus Act, which is many chapters with different forms of marriage. That is a middle option in our opinion. Then there is the separate acts, which are the existing situation, which we believe are preferred. Our objections to the marriage bill that is being proposed is firstly that so-called same-sex marriage is put in the same category as real marriage between a man and a woman. Secondly, that any marriage can become polygamous even if that person has promised to be faithful to one wife. Now, this is a proposal which I'm not aware of any other country in the world which allows a person to covenant to one woman and then decide to change his mind later. If, for example, you are in Nigeria or in India and you covenant with one woman for life in a monogamous marriage, you cannot change your mind later and decide you want to become polygamous. Women are easily pressurized and in a vulnerable power position, economic position, and I don't accept this view that the court is going to be able to check whether there is consent. There can be pressure. So any man can take a second wife. We have a major objection to that. That is completely different to a person who is in a particular tradition, such as, for example, African polygamous tradition or Muslim tradition, which has checks and balances internal in it. And people are living in the constraints of that community. This now is an attempt to radicalize and change monogamous marriage for all, which is definitely a socially preferred form of marriage. There is documented academic research showing the benefits of this marriage, and the vast majority of South Africans are moving towards this form of marriage with a preference. Then there's the problem of religious freedom risks. That we have had repeated assaults from LGBT activists on the right of religious people or moral people not to want to participate in this marriage fraud or calling things marriage that are not marriage. Then there's the problem of moral confusion that is caused by this process of recognizing things as marriage which are not actually marriage. So the threats to marriage officers, this bill has no protection for state marriage officers. The pastors, there is an exception clause for pastors not to be coerced to do same-sex marriage, that is religious marriage officers. But that clause can be removed very easily, just as it was in the case of the Civil Union Act, and we predicted that would happen. It did happen. We have a lobby group that spoke earlier that wanted removed, and I'm sure they will continue to lobby in that direction. If we keep it in separate bills, there is no chance of that happening. There's no chance of litigation. Pastors don't have to defend themselves because they are not registered to do anything other than marriage between a man and a woman. So we oppose that. There are some risks which have been raised by previous speakers of freedom of religion essay about the interpretation of clause 17, which I will not repeat, but I agree with what they said there. Now, I would compare this removal of this boundary by moving these different forms of marriage together with the removal of the borders, the natural borders of Czechoslovakia just before World War II. It had defensible borders in this blue area, which were mountains. As soon as they crossed those, they continued to cross the next thing. We have a defensible border at the moment, which is separate marriage acts. Then there is the issue of the need for multiple defenses to protect any kind of security, including religious freedom and even your own home. You don't rely on just one thing, for example, a dog or an electric fence. You want as many layers of security as possible, and these separate marriage laws give us a layer of security. People are registered to marry in terms of one marriage law, which is between a man and a woman, they are not then put under threat. We would like that defense to be added back to state marriage officers. Now, this is a toxic experiment that no country in the world has ever tried before and can have disastrous results. That is the combination of same-sex marriage, polygamy, and gender change, which we had one of the previous speakers advocating in favor of and wanting to extend that. The history of this is the wrong ruling of the Court in 2005, which we hope will be reversed, just like Roe v. Wade was reversed, and then later the Civil Union Act that came out of that, and then the removal of in 29 to 2020 of the protection of home affairs workers, which we believe need to be restored. Now, we predicted back in 2005 that following the trends in other countries, this legalization of so-called same-sex marriage would lead to a drop in the number of people getting married. And that is exactly what happened, which is, which you can see in the graph above, which is approximately halving of the number of people getting married versus just living together and still having children. That is a disastrous situation, which I would compare to the problem of Eskom not generating enough power. Eventually, it results in the disaster of load shedding. These children growing up without fathers stable in the home is a social disaster that this will fall on the state to have to deal with eventually, and they don't have the capacity to do that. So what we want to do now is strengthen marriage. The destruction of marriage and undermining of marriage leads to school dropout, low marks, gangs, drugs, poverty, joblessness, teen pregnancy, and social grants. That can be statistically proved. This is not just a religious issue. This is a catastrophic economic and social problem. Then there is the recognition of sinful relationships as if they were marriage. This is the combination of so-called same-sex marriage with marriage between a man and a woman. But at least they were kept separate on a separate register, and people didn't have to be involved in them in this Civil Union Act. Now they intend to combine these things. And no, this was not just an oversight in 2005. The government opposed this Constitutional Court ruling. They fought it at every step. Most of the parliamentary representatives of the ruling party were opposed to this, and this was a compromise that they agreed to. It was not just an oversight, and it was there for a reason. I would also compare this recognition of counterfeit marriage with recognition of counterfeit money. It undermines real money. Now then, there are 7 false arguments that have been put forward for this thing. First is a bait and switch argument of the Muslim divorce ruling. Firstly, we've heard from the Muslims that they don't want this bill. They want their own bill or the omnibus bill. And secondly, they are not in favor of same-sex marriage. Then the argument that this is required by the Constitution. Now, this we've had from both Albie Sachs and Kader Asmal, that this was agreed in Dublin in Kader Asmal's kitchen, that they would include sexual orientation in the Constitution. It was not approved by the South Africans in this country. Albie Sachs, the same person, then rules in favor of same-sex marriage in 2005. And he reads an enormous amount in 2 words in the Constitution that nobody had even proposed at the time the Constitution was written. The simple solution to this is remove it by a constitutional amendment, similar to what many other countries have, recognizing marriage between a man and a woman. Then the argument that you can't bias Christianity with monogamy. Now, India, for example, had polygamy for thousands of years. They have only 2% Christians, but they decided that they would have one man, one woman marriage, except with the exception for Muslims, since 1955. Then the argument that it is tidying up fragmentary marriage laws, I would say there was a compromise in 2006, which was reluctantly agreed on between the government and the Court. Most of Parliament opposed this thing. And now this is pushing this radical agenda much further. Customary law is vanishing. Most people are not choosing that way to get married. And this would have very, very major impacts. Then the argument of democracy. There was no vote on sexual orientation in the Constitution, no vote on same-sex marriage, and the polls are showing that almost nobody supported the decision to legalize same-sex marriage in 2005 and 6 and continue to oppose it. Then the argument of African culture. African culture does not support same-sex marriage and is already accommodated in the Customary Marriages Act, although fewer and fewer people are choosing this option each year. Then the argument of international law, and there's a law on discrimination against women that was cited. I have a map here of the countries in green that have agreed to that law. These other countries do not have anything like this proposal. Only the red countries have not signed this thing. We can see that this is a completely misleading argument. The other argument that was put forward by a previous speaker, which is highly misleading, as a reference to the Yoga Carter principles as international law. They are not international law. This was just a conference of non-profits. It has no status in the United Nations.
Sorry.
Okay.
Okay, you're working towards a conclusion.
Okay. So we argue the constitutional amendments of delete sexual orientation and marriage between a man and a woman only. Listening to the presentations and submissions of the Muslim groups, and the Constitutional Court ruling, we've identified 4 issues that we need to consider. The one is the presence of the woman at the ceremony versus a proxy. The second is retrospective recognition, and third, potentially polygamous. The fourth is the request for a parallel cultural law. I think the first 3 issues are recognized by the Women's Legal Center ruling. The first 2 could be accommodated within the Marriage Act. The third could not, but the third could be accommodated within a chapter in the Customary Marriages Act or a separate Marriage Act. The fourth would have to be in a separate Marriage Act. I think the simplest approach to responding to the ConCourt judgment would be to simply codify what they have ordered and nothing else. And then to consider other proposals after that. This bill would cause major social problems. It would be akin to bashing down the structural walls of a house rather than doing interior decorating changes. And we would have a much worsening of an already problematic situation.
Oh, thank you very much, Ms. Rosenthal, for your contributions. One of the areas that you need to learn, Mr. Rosenthal, is to benchmark your language. We were not necessarily, or not at all, have interacted with the presentation, but it's important that when we raise our issues, we don't seek to denigrate any other category in society. And secondly is that you have indicated that one of the presenters were misleading this meeting. And I don't think that it's your call to articulate in the manner that you have suggested. You could have grounded your motivation to contest the views that have been raised. So I wanted us to raise those 2 points so that we were able to recognize that all the submissions are important, including yours, but none of those that have presented before have referred to each other as in the manner that you did. I'm trying to be firm on the because you're not only talking to members of the committee, but also the public. I've been observing your comments throughout the public hearings. I must say, it won't help you and us. So we need to benchmark our language. Noted. Thanks very much for the presentation. Can I check if there's any other presenter, before I invite members, if you might have left something that you wanted to add, if there's any other presenter. Those that are presented, if there's any other matter that you might have left or you wanted just to add, so that at least we close this item and invite.
So, Honourable Shabane, the Free Society Institute were on the program also. Sorry to interrupt you.
Oh yeah, we've called you earlier on. You're the second or so. I'm not sure why. What were the difficulties for you to attend? Mr. Matwenzi, you wanted to say something before I recognize the.
No, I wanted to indicate that the Free Institute was Free Society Institute. They are in the meeting as well. Okay,
I think they will indicate why they so that we're. But can I check members of or presenters if there's any other matter? Maybe you can deal with that once the Free Society has presented, so that when we interact or Advocate Malikat or the DG interact with the matter, at least we have exhausted issues that you wanted to raise with the committee. You can proceed. We have laid rules that must guide our meeting, and now that you've joined late, you didn't benefit to that. You have been allocated 10 minutes, but we are not. If the 10 minutes allocation goes beyond, will not suppress you, but will guide you on how you must conclude your matter. Thanks very much. You can proceed.
Thank you, Honourable Shabane and the other members of the PPC. Our apologies, and we were scheduled for 11 and I couldn't join earlier, so didn't realize that we had been rescheduled. I won't need 10 minutes. You have my written presentation, and Eddie, can my slides be shown, or should I show them myself? There we go. Thank you very much. As an introductory remark, I would just like to commend the legislators for, at least in the Civil Union Bill and in other legislation, for trying to maintain the progressive ideals of our Constitution and Bill of Rights and so forth. So I think this Omnibus Bill is a continuation of that, but despite that, we do have a few concerns, and one of them stems from comments made by earlier presentations that I was able to hear, which is the conflation of atheism and secularism. Because our intent, summary intent of our presentation, is to try to highlight that a secular orientation in such a bill actually allows for maximal freedom of religion, as well as freedom for those who do not subscribe to religion. Because the state's responsibility in this case is just a civil role, and religious organizations can supplement that with whatever religious prescriptions, as long as those are compatible with existing legislations that they like. I won't belabor the committee, the PPC, with references to exact clauses and things, because those are in our written submission. So the starting point, and you can progress please on the slides. The starting point would be to say that there are framings throughout the bill which privilege or preference certain ways of thinking about unions that hark back to even the Marriage Act. So starting with thinking about polyamorous marriage, it's here defined as polygamy, which excludes polyandry, right? So there's a framing there that only preference, that in a sense is misogynistic, in the sense that it preferences only a certain kind of direction of gender recognition. We also think that the bill contains lots of language that is gendered. I'll come back to a few of these points later on. And I think that these definitional aspects can allow for contestation and perhaps introduce the possibility of legal challenge on purely secular grounds, in the sense that they're discriminatory in a way that overruns what the state's role in fact is. So on the clause specific, continue. Thank you on the slides. So clauses that refer to things like husbands, and as I say, the framing of polygamy is firstly a problem. Chapter 3 includes many of these concerns. It needs rephrasing to ensure equal protection for polyandrous marriages and broadly an inclusivity. I've mentioned point 3, and So yeah, we would recommend an overall review to eliminate such language. You can proceed on the slides. Thank you. And then there's a number of legislative, perhaps, concerns or inconsistencies. There's a difference in treatment between certain categories of marriage officers, the ex officio ones who are granted indefinite status, but others have to renew their authority. And the bill does not provide a rational basis for that discriminatory treatment. I'm concerned by clause 7.2 on the grounds of practicality as well as legality, because it designates roles with regard to other countries and the scope of marriage officers and their roles in other countries, which falls outside of our authority as South Africa. And then lastly, following on from that, we would recommend retrospective recognition of all the previously registered officers, clarity on the international roles, and then fair treatment for all marriage officers going forward in terms of renewing. And a last section, going back to the state's role in these things, just to re-emphasize that the state's role is to provide the civil recognition alone. The rest, anything to do with whether one is non-religious or religious or what sort of religious beliefs one has, fall outside of the state's proper role here. The state's role here is to provide the bedrock, the foundation, which is entirely objective and neutral with regard to all of those things. Ways to emphasize this in terminology, I've mentioned some of them, but also words like union as opposed to marriage are neutral in these respects. I mean, as you would all know, in the CU bill at the moment, one can choose whether one wants one's union described as a marriage or a union, which is a very sound starting point. And the partnership rights should not, in the state's position, should not include any kind of privileging of any kind of cultural significance. It is a recognition of a civic situation, of a union between people. Proceed, please. And that leads to just an explication of what the risks and challenges are. As I've said, there's the gendered norms problem. There's the archaic and pejorative language, which and pejorative in the sense that it privileges a certain kind of union rather than other ones. I worry both about social backlash in terms of that discrimination, and secondly, that there may be challenge, which requires further legislative amendments in the future. And proceed on the slides, please. And lastly, our summarized recommendations: the equal protection, the neutral terminology, the future-proof legislation, which is more robust and less susceptible to future challenge. And as I say, this is all in the attempt to make the state's role as a neutral arbiter more coherent and clear, and to prevent challenges in future. There's far more detail in our written submission. I just wanted to present that to you, and mostly say that we should beware of the confusion or conflation between secularism, which is granting equality to all, regardless of view, versus anything like atheism, which of course would be exclusory of religion, and that is certainly not the intention of the Free Society submission, nor the intention of secularism as a whole. Thank you, Honourable Chibane, and the other members of the committee.
Thank you very much for your time, and thanks for the contributions. I must thank all of you for having contributed to this discourse of the marriage proposed bill. Is there any of you presenters who want to add, or you might have left something that you need to make an addition? Okay. It means you will then interact with members. Members, is there any other question before I invite Advocate Malekate to respond to or to comment on the issues that have been raised? I will invite Honorable Ross. I'll start with Honorable Ross. You can proceed, Honorable Ross.
Thank you very much. Thank you, Chair, and thank you to the presenters, Chair. I have to say this has been tremendously valuable inputs, as much as we've gone around from province to province. And I'd like to congratulate each and every presenter for the clarity with which you presented. I think the salient issues have been picked up. Chair, I just have a few questions of clarification. starting with the Triangle Project. And I know you mentioned that you're including the Women's Legal Center input. My question to you is, do you feel that the issues of the judgment regarding the position of women in Muslim marriages has been covered by this bill? I figured there might be some input on that, in terms of has the judgment been covered? And then also, what is your view on the default property regime? Given that it seemed to be a part of the judgment was that that affected persons were left destitute because of the marriage property regime. Then for SA, I think it was an interesting point in terms of the separation of the ceremonial portion from the legal portion. And this appears to be in the white paper. Chair, I'd like to get Advocate Malakate's view on why that was removed, and also whether there's any risks in taking this approach. Then my question to 4SA would be, if you had to go that route, I think if you look at customary marriage, for example, and Muslim marriage that's solemnized by religious rites and then registered, what would be the mechanism for LGBTQI community? Because unlike a religion, they wouldn't necessarily have other rights or specific rights whereby they would then perform the ceremonial portion. And then you would need to have a class of marriage officers, for example. What if there wasn't a marriage officer in a remote area? So I'd just like to get your understanding on that. Then Prof. Van Wyk, thank you very much. I think it is an important point to point out that the property regime does sit in the Matrimonial Property Act typically. But would you say that changes are required to that act to give effect to the concerns of the Women's Legal Center case? And then secondly, I'd like to get an understanding, Article 21.2 of the African Charter on the Rights and Welfare of the Child, 1990, explicitly states that child marriage and the betrothal of girls and boys shall be prohibited, and effective action, including legislation, shall be taken to specify 18 years as the minimum age of marriage. I'd like to get your understanding of whether this is binding on South Africa and binding on us as lawmakers in South Africa in terms of the minimum age of marriage. Then the United Ulama Council, Mr. Mohammed, I'd just like to get your view on how the current system is working, where, what Mr. Haron spoke about, in terms of the being able to take the nikah certificate to Home Affairs and then have the marriage registered. How is that current system working? Are there any gaps currently in that system? Because it seems to tie into the proposal of saying you separate the solemnization from the registration. It seems to be what's happening in that case. Are there any things that are not working in that regard? And then, if you looked at the proposal of 4SA, for example, the separation of the ceremonial portion from the legal portion that was in the white paper, would this resolve the issue that you had mentioned in terms of, the recognition of religion within this act? If there was a separation of the ceremonial portion from the legal portion, would that resolve those issues for you? Thank you, Chair.
Thank you very much, Honorable Ross. Can I now get the presenters to comment on the issues that Honorable Ross have highlighted? I'll start with the...
Sorry, Chair, my hand is up. Up.
Oh, so yeah, I can't recognize it. Yeah, I think there's a problem, challenge of something. You can proceed, Honorable Machi.
Thank you very much, Chairperson. Firstly, we've got to welcome the presentations with their different views for us as the committee as well as our respective officials, led by Advocate, will gain some of or out of them. My first question will go straight to Professor Van Wyk because it says it's independent. Sir, you argue that the individual choice, argue that the individual choice of a multimillionaire property regime proposed in clause 15.2 is practical and unpractical and would create chaos in our private international law. Can you elaborate on the specific cross-border legal conflicts you foresee in South Africa upon a standard default legal regime? The other issue is pertaining the proxy marriages. You raise concerns about the reintroduction of marriage by proxy in clause 11.2. Given modern videos, conferencing technology, do you view the risk of abuse and stemming from vertical of identity or from a lack of genuine consent? Thank you.
Yeah, thank you very much. Is there any other hand, members? Okay, okay.
Okay. Thank you, Chair. It's Kensani from the Women's Legal Center. I just wanted to give a brief response to the question on what our views are on the marriage bill, especially considering.
Okay. Let's hold it there, Ms. Mutileni. I was on the invite for members. If they've commented, then we'll start with the triangle project. Then we'll come for SA. We'll come to Mr. Van Wyk. Then we'll end with you to comment. I'm sure, and other members, I just want to start with the direct questions to specific stakeholders. Can you proceed, triangle project?
Chair, Kensani from the Women's Legal Center will be answering our questions. It was a joint submission with Triangle Project and Women's Legal Center.
No, thank you. Proceed.
Afternoon, honorable members. Our presentation on this issue in particular is tomorrow morning. So I will then get a chance to unpack how we have reflected on the bill itself. However, I think it's just very important for us to just make it noteworthy that the Women's Legal Center is not opposed to any process as long as the lived realities of women are reflected in any type of legislation and that women have legal certainty. So as long as it meets the constitutional muster, we don't have any opposition to any piece of legislation as long as it advances the rights of women and vulnerable groups. But I will get into further detail tomorrow when I take the committee through my presentation. And with regards to the Divorce Act amendment, which was passed last year, the Women's Legal Center has welcomed that, even though there have been challenges in practice throughout this year on what the actual application looks like, because from the judgment from the Constitutional Court, we would have noted that it states that the default position for Muslim marriages is out of community of property, which is very different from our out of community of property, where you'd have an antenuptial contract deciding whether it's with or without accrual. So we have been in conversation with our partners and other legal practitioners on finding a template on how to better finalize divorce matters that have couples that were married in terms of Sharia law. However, one of the main provisions that we we really do welcome is the fact that the women are allowed to request the court to make a just and equitable distribution of assets, even though the marriage is out of community of property, because we understand that some of these women and the profile of women that we presented to the High Court in 2014 were already in their 60s and could not re-enter the job market. So I think for us as the Women's Legal Center, we have welcomed those advances. Thank you.
Thank you very much for your comments. Free Society Institute.
Sorry, Chair. Chair, I did not. Is there a question for
Oh,
us?
no. Sorry. I'm saying Freedom, Religion, South Africa. I think there's a question that was directed to them. Thank you.
Thank you, Honourable Chairperson, and thank you for the question, Honourable Rose. I'll just read from the white paper what it says. It's on page 30 of the white paper, Recommended Policy Intervention and Rationale. DHA officials will be required to provide marriage services to all members of society. Officials will, however, not perform any ceremonial functions generally associated with solemnization of a marriage. State functions must not be conflated with those of the religious or traditional formations. So our interpretation of how this practically could play out is that instead of having any ceremonial component, when you go to the department, that official there, they only do the paperwork. And then whoever you are, however you identify, whichever community you belong to, if you want a ceremony, you then go to a place where you can have a ceremony. If you don't have a marriage officer in terms of what this new bill will provide, who caters to your specific community, your group, so that the state official only does the, fill in the form. So the state recognizes as a legally valid marriage in terms of our marriage legislation. Department of Home Affairs provides service delivery equal, fair to all who is allowed to be legally married or enter into union, however you want to name it, in terms of South African law. And then that couple can go and have their celebration at a separate place with their family and their friends and their loved ones.
Thank you very much. Thank you very much for the responses. Mr. Prof. Van Wyk.
Yes, Chairman. Thanks. First of all, Mr. Roos, the minimum age of marriage. Of course, we are bound by our international treaty obligations. And of course, the age of 18 is very, very important. But we have to weigh that up against the personal consequences for young people of illegitimacy of their child, even though the consequences of illegitimacy have been reduced very much. The social shame still of being an unmarried couple with illegitimate children. I know these things have been changing a lot, but in many of our communities, those things are still a reality. And I'm of the view that if we were to retain the present position of allowing a back door to open by permitting a special permission for those young people, we would not necessarily be contravening that treaty, which does, of course, apply to us. Then the second one, the Matrimonial Property Act, you must remember that, in my view, Chapter 6 doesn't belong in this act at all. It's not part of the mandate of the Department of Home Affairs. The whole matrimonial property issue, divorce, etc., have always been part of the mandate of the Department of Justice. And the Divorce Act of 1979 was brought in, etc., and is still governed by the Department of Justice. Therefore, Clause 16, for example, doesn't make sense at all. And then, as far as Clause 15 is concerned, we must remember that the South African Law Commission has been having a project for a number of years now about possible changes to the Matrimonial Property Act of 1984. There's a subcommittee consisting of experts on those possible changes. So once again, Clause 15 doesn't belong in this bill at all. It contradicts everything which the Department of Justice is contemplating. And I find it amazing that the Department of Home Affairs hasn't been really properly consulting the Department of Justice in this regard. Then, as far as the lady's questions is concerned, the Clause 15 I've already spoken about. I don't know whether there are any other questions in that regard from her. As far as marriage by proxy is concerned, my main concern, all right, you have modern social communication media, you can have a marriage by Zoom, etc., etc. But my main concern is fraud. We have a huge problem with fraudulent marriages, using marriage as a medium to obtain South African residence or South African citizenship. And I don't think there's such really a need. If you want to get married, then you should get together. And the possibility of fraud using the social media and using the renewed possibility of marriage by proxy, not good options in my view. Thank you.
Thank you very much, Prof, for your comment. Can we now invite United Alma Cancer?
Thank you. Thank you, Mr. Chairman, and thank you for the question. Two questions were posed to me. The one was whether the nikah certificate system currently at Home Affairs works, and the other question was the separation of legal and formal systems, how I feel about the second question. So I want to answer these two questions together. Let me first concentrate on the Home Affairs nikah certificate system. I don't know to what extent it is really implemented. Number one, I'm not saying it's not. All I'm saying is that I don't know. Number two is I do not believe, and this is a view that is widely held by legal scholars, that that certificate is in fact unlawful. We have written to the two Home Affairs on two separate occasions, giving our legal opinion on why that certificate is unlawful, and it is not, in fact, it is contrary to the orders by the Constitutional Court, all three courts in the Women's Legal Center case. We do not believe that that is a lawful certificate. When challenged that in court, then only it will show that that is not a lawful certificate. So currently what is happening, not regarding that, just what has been happening in Muslim marriages forever, including now, is that a couple gets married in mosque before the imam. That marriage is concluded. Then a separate marriage is concluded to satisfy Home Affairs. The second marriage is registered at Home Affairs. And that second marriage is concluded or solemnized by a marriage officer. So that Muslims have been doing for many, many, many years. And they've been doing that since Home Affairs authorized or accepted Muslims as marriage officers a few years ago. Then two marriages took place, a Muslim marriage before the imam and a marriage act marriage before the marriage officer. Those were two separate marriages. So still, the government did not recognize the Muslim marriage, it recognized the separate marriage. Regarding the nikah certificate, that is exactly what is happening now. It is just called something else. Still, the Muslim marriage is not recognized. What we are arguing for and what we are saying is that Muslim law, Sharia law, regarding marriages and regarding divorces should be recognized. Like the Muslim marriages bill, something akin to that must be recognized, and that is a constitutional imperative under Section 15(1) of the Constitution. And there, so far, and that is being denied. And it is not difficult. It is not difficult. Yes, the government is saying that there are many people opposed to it. The facts on the ground is that there are not many people opposed to it. There is a simple reason for that, is that there is one group opposed to it, and the group is very loud. That's all. Nothing else. It's just that the group is very loud. But that is not how government should be looking at it. The government should be looking at it from a constitutional point of view. Our constitution is a constitution of individual rights, not a constitution of group rights. Individual rights means that the government has an obligation to ensure the individual rights, or rather the constitutional rights of each individual person, not each individual group. That is Constitutional Law 101. That government has the obligation to ensure that every individual's rights are guaranteed. And when an individual comes before government and says, my rights are being violated because you don't recognize my religious rights to marry in a manner that I want to be married, then government is telling that individual, well, there are some people somewhere else who disagree with you. That is the wrong approach. Other people cannot decide whether an individual has a right to the freedom of their religion and the religious marriage law. Whether that people are of the same religion or not makes no difference. If a Muslim person cannot tell a Jewish person how they can marry, so too can another Muslim person not tell a Muslim person how they can marry. The government's obligation is to the individual. Again, I will say, Constitutional Law 101. I want to change to the question, it wasn't posed to me, but if I may, Mr. Chairman, with your permission, comment on marriage officers. The point has been made clear about marriage officers who are not in the employ of the state. I want to speak about marriage officers who are in the employ of the state. When marriage officers who are in the employ of the state are forced to solemnize marriages contradicting their religious rights, that is unconstitutional. Government is forcing state employees to violate their religious rights, their religious freedom rights. This is unconstitutional. The obligation on the state to provide marriage officers to solemnize all different types of religion is on the state, not on that individual person working for the state. If, for instance, a Christian who objects to performing a same-sex marriage, or a Muslim who objects to performing a same-sex marriage, that person is within his right to object. Government cannot force that person to contradict his own religious convictions to perform that marriage. The obligation is on the minister to ensure there is somebody else who can perform that marriage, which is not on the person, it's on the minister and it's on the state. The problem regarding in-community of property and out-of-community of property questions. This has been mentioned a few times here today. And it is well known and it's been confirmed by court decisions that Muslim marriages are by default out of community of property. There is no problem with it. The problem that people have is they do not apply proper legal principles in determining what the estate of the one spouse is and what the estate of the other spouse is. We are too used to the system of in-community of property that we do not know how to differentiate between spouse A's estate and spouse B's estate. And the current system of Section 7.3 helps to ensure that estates are properly identified. And regarding the age of marriage, Mr. Chairman, with your permission again, government is imposing age legislation from international law and South African law on religious persons who do not have that restrictions in their religion. And to date, the only argument that government makes is to say that we have international obligations. That is not an argument. That is just a policy. It is not a legal, rational argument. The government has given in the green paper numbers. If you look at those numbers, you'll see less than 1% of people under the age of 18 ever get married to each other. And the purpose of this is to ensure that the girl child is educated. The government has never shown how many girl children get married under the age of 18 and then don't get educated, and what percentage of South African population is caught up in this trap, and then it affects the rest of their life. And yet this is imposed on everybody. If government shows a significant number of people, children, get married under the age of 18 and then they don't get educated after that, that is an argument. Government hasn't come up with an argument like that. So to impose this policy on everybody in South Africa without a proper argument and just saying, well, we are bound by international law, that is not an argument. Thank you, Mr. Chairman.
Thank you very much for your responses. Is there any other participant who want to respond or take a bite?
Yes, Honorable Chair, may I?
You can proceed.
Mohammed Harun here. Yeah, thanks very much. Firstly, I think as Advocate Mohammed indicated that I think for generations now, the Muslim community continued with their practices in terms of performing the marriage, so to speak, internally. When I say internally, externally, I mean within the Muslim community, according to the understanding and interpretation of Sharia within family circles. So that has remained a practice, and up to now, it still continues in that fashion. Secondly, pertaining to that is the though of course the legal system wants Muslims families to couples to marry in accordance with African law, some have resisted in doing so, partly because as long as they have a will according to the Muslim system, then they basically continue in that fashion. And so when they pass away, the will itself explicitly indicates that whatever assets they have and whatever they need to distribute must be done according to the Muslim will. So in that way, they are covered, so to speak, internally. With these developments taking place sort of on the external front of these Muslim families, we basically, of course, we are challenged, as you heard Advocate Mohammed indicated, for example, the Muslim marriage certificate that is now being issued by Home Affairs. Of course, I do not necessarily agree with what he had to say, that it is totally unlawful. Of course, maybe if the argument is that it's basic against the Constitution, then that has to be revisited. But in the circumstances, it's a relief for these families and those who had gone, and they have some who have gone. Perhaps we don't have the statistics, and perhaps Home Affairs should be able to provide us as to how many of these Muslim couples have gone to the come to Home Affairs to require to be issued with one. I think that will help us to give us this understanding of how many have gone and how many haven't. And other, if it hasn't sort of succeeded, then perhaps another plan will have to be put in place in order to do so. But essentially, what from outside of Al Jamaa, we see that at least it is a way out for Muslim couples. In other words, there is a way where the Muslim marriage has now been given sort of recognition within the state itself. So, of course, there are anomalies, there are sort of issues that will always sort of be hanging in the air, but we need to find some way of solving that. The last point I want to make is that I think, and as I've said also early on, and of course, this comes to the issue of polygynous or bigamous marriages too, because whilst the one presenter indicated that customary law polygyny is thinning out, it need not necessarily be the case. It might still be prevalent. And of course, when you talk about extramarital relations, there are so many that are impacting negatively on the society that all of these issues will have to be factored in and to be thought through. But that aside, I think the coming back to the Muslim marriage scenario, I think we have lots of internal challenges. If you have heard from Advocate Muhammad, partly because of the constitutional matters as well as sort of internally within the Muslim society. So, of course, there are ways to overcome these. And perhaps I need to just say that whatever the outcome is, it also impacts upon the other sort of acts, whether Divorce Act, Arbitration Amendment Act, all of these things, all of these sort of other acts are impacted upon, and we need to look at it holistically. Of course, internally, within the Muslim communities, particularly our legal eagles, as well as outside of with others, so that at least we have a better understanding and application and hopefully an appreciation of these outcomes. I mean, we've already been at this for literally for so many years, for rather decades, and it has still not been resolved. But that said, I think there should be ways out, and I'm sure we can find, even if it has to be certain compromise, not on principle, but compromises in terms of the application, because I think we need to ensure that our communities, the individuals, the couples, their dignities are being kept intact. And this can also be undermined by some of these practices. Thank you very much.
Thanks very much. And we thank for availing yourself and creating time to contribute to this marriage bill.
Mr. Chairman, may I say something?
Oh, I thought I invited comments from stakeholders. Can you hold there, Prof?
Yes, sure.
Yes, yeah. To thank all of you for having commented on this marriage proposed bill. Is there any matter, Prof, you want to comment? Then I'll invite Advocate Malikate. Then I'll hand over to Honorable Sitlenguban.
Sorry to be a bit late. I just want to add that it's not that simple with Muslim marriages, because Muslim marriages entail a subjugation of the woman to the rule, let's call it, of the man. And therefore, there are problems regarding the constitutionality and particularly the principle of equality of the sexes when it comes to Muslim marriages. So it's much more intricate than I think many people think. Sorry about that. Thanks a lot.
No, thanks, Prof. Advocate Malikate, it's your time now to Advocate Malekate as part of the team that has initiated or developed initiated a white paper and developed the bill. Advocate Malekate.
Thank you, Chair, and good afternoon again to you, Chair, as well as the honorable members of the committee. Chair, let us thank from the department side the oral representations that were placed before the portfolio committee today. I think they were quite exhaustive, and they should assist us in the work that is ahead of us in relation to the further development of the bill itself. Chair, having said that, there are just quite a few number of issues that we thought maybe we could just clarify, and we're not providing responses, but just clarification to the presenters of the day, just to take on board. And the first issue that we wanted to deal with is relation to the minimum age and to be able to participate and conclude a marriage, which is 18. And I think Honorable Ross, by referring to the international instruments, has captured it quite correctly. But we just also need to come back and look at what Section 28 of the Constitution itself says. And in particular, if you look at Section 28.2, it contains a definition of what is meant by a child. And you would see that a child is defined as any person who's under the age of 18, which therefore means that any person who's above the age of 18 or 18 years old is then regarded as an adult. And the bill simply seeks to create an opportunity for a person who is either 18 or years or above, in the event that they so choose to enter into a marriage, that they can do so. And Prof. Van Wyk then refers us back to the current Section 29 2 of the Marriage Act, which then provided some form of a mechanism where a child under the age of 18 could have been allowed to enter into a marriage. But I think in terms of this bill, we are now seeking to ensure that the international obligations that we have together with the Constitution that then that become codified. When we move to the issues that is raised by the Ulama Council of South Africa as well as Mr. Heron relating to religion, I think we also need to be reminded, Chair, that when we look at Section 15 of the Constitution itself, together with Section 31 of the Constitution, which guarantees the right to freedom of religion, you would see that there is also some in the very same provisions that there is a requirement that whenever we are practicing our religion, such religion must not be inconsistent with the Constitution nor the Bill of Rights itself. So in actual fact, then it means that whatever religion, as we practice it, it has to conform to the constitutional values, but also to conform to the Bill of Rights. So there is that element that we need to consider, and so as you would know, that the rights that are also contained in the Bill of Rights, they are not absolute in nature. That they may be limited in certain circumstances, and they may also be limited by way of a law of general application. And this marriage bill it's a law of general application, and so it wishes to ensure that that it conforms with the Constitution together with the Bill of Rights. And I think the other issue that we wanted to clarify, it's in relation to the opt-out mechanism that you find under Clause 11.4. And I think some of the presenters were indicating that those who are employed within the state should should also be allowed to then opt out and indicate that they would not be able to solemnize marriages where such would be in conflict with their religion or with their belief. And I think similarly, there's also a submission that says there has to be a separation between the ceremony itself as well as the registration of marriages. And when we look at that, we also need to be reminded that there are maybe instances where an individual opts to approach the Department of Home Affairs for his or her marriages to be, for their marriages to be solemnized within the Home Affairs Office. And in that case, the department should be able to provide such a public service. So the opting out mechanism for public servants, if you would see from the bill, we are following what has already been adopted by Parliament in 2019, wherein we say, as a public servant, you should be able to provide public service without discriminating either on the basis of gender and so on. And we are also reminded of the obligation that is on the state in relation as it comes up from Section 7 of the Constitution. And by extension, that obligation is then upon a public servant, and which obligation is mainly to ensure that the state must bears the responsibility to respect, to protect, and promote and fulfill the Bill of Rights. And when you read Section 9(1), equality means you have to have the total full enjoyment of that right that you have in the Constitution, and therefore, as a public servant, you need to provide public service without discriminating on the basis of gender, sexual orientation, or otherwise. So that is the rationale why the bill is captured in the manner that it is. So, Chair, Honorable, there were also submissions relating to what the Ulama Council says, an omnibus legislation, wherein we needed to have chapters dealing with various religions, so to say. And I think also Honorable Ross has also raised this and asked the question: are there any risk involved that would have been identified in creating a legislation with various chapters dealing with various religion and so on? So if you were to go back to the white paper, in the end, the white paper itself then obligates or advocates for a creation of a single statute that deals with marriages entirely within the Republic of South Africa. And in that, the white paper advocates just not for us not to do so as per religion, and have various chapters dealing with various religion or cultural belief or belief. So then what the marriage bill then seeks to do is just to simply say, or to respond to the answer that says, our marriages would remain marriages, and they would have been concluded, of course, in line with the tenets of either a culture, either a religion, and so. But what is important is that those are defined, those are marriages, and therefore they needed to be recognized, and also that we need to register such marriages, and therefore that was the reason why we needed to come up with a single statute dealing with marriages, and there are no risks that would have been involved. It's just that if we were to look at South Africa as diversified as it is, then it would mean that we may have had to deal with various chapters, perhaps dealing with the Muslim personal law, dealing with Hindu law, dealing with Jewish law, dealing with any other culture, because it may very well be that some of the cultures also differ, and persons would then say, we need our culture to be recognized, which would have made this statute so big that we may have difficulties in terms of the implication, the implementation thereof. But in the main, Chair, I think most of the submissions that have been made are around that. But we welcome the representations that we have, say, for what we just needed to clarify. Thank you, Chair.
Thank you very much, Advocate Malikate, for noting some of the important issues from the meeting and also commenting on some of the issues that informed the content of the bill. I will now invite the Honorable Gubane.
Thank you very much, Chair. And thanks as well from everyone who contributed to today's public hearing. Now that we've come towards the end of our program, the public hearings, and I think the Home Affairs has come and responded to many issues that were raised by the submissions. The way forward will be as follows. The committee will then go and deliberate on the contents of the bill, taking into the account all the submissions that we have had today and the previous ones where we went to the public hearings and collected all these submissions. That will be a formal stage that will happen in the Parliament, and then in the Parliament, as a committee will then go debate. The committee will then draft a report out of all this collection and adopt it as a committee, and then go and present that report in the National Assembly now for the debate by all political parties involved in the National Assembly. So that's the process that will unfold after this. And then subsequently, once we've debated and adopted this report of the bill in the National Assembly, the bill will then be referred to the second house of the Parliament, the NCOP, so that it can embark on their legislative process as well and do their own work of their own NCOP-related work for legislating. And thereafter, once the NCOP has completed its work as well, the bill then will be sent to the President to assent so that the bill can become now an act of Parliament. So that's a whole process that will happen after this. And then tomorrow, we will have other public hearing submissions tomorrow at 9. So there are still public hearings that we will be listened to and hear the submissions. So there is a day for tomorrow as well for the submissions of public hearing. I think in a nutshell, so that's what the whole process will happen from here onwards after this. So we really appreciate all the presentation, and we've warmly listened to everyone with anticipation and perseverance. And we assured all of you that your contribution will be heard, taken into consideration in the report. None will be ignored, and none will be seen as small or others as bigger submissions. So we appreciate all the presentations that have been done. So I think in that nutshell, that's my contribution on the closing remarks and the way forward of how we're going to move forward from here onwards. So in that nutshell, Chair, I hand over to you to then close your meeting officially, if then we've done justice to the whole presentation. Thank you very much, Chair.
Thank you very much, Honorable Mgubane and honorable members. The meeting stands adjourned.
Thank you very
Chairperson.
much.
Thank you very much.
Okay. Thank you.
Thank you.